So now it's my pleasure to introduce Jane Cohen. She has been an arbitrator since 2007 and a practicing attorney for 35 years. Presently, Jane serves on multiple panels, including Alaris, FINRA, and AAA, which includes their large and complex panel and construction panel. So with that, Jane.
Thank you, Jennifer. Thank you for joining me for lunch today. And we are not going to take a poll of the people who are in attendance, but this program hopefully will be good for both transactional lawyers as well as those who litigate, and will also provide good information for those who also serve as arbitrators. First, we'll discuss the evolution of arbitration and then drafting considerations for arbitration clauses. And finally, if we have enough time, we'll talk about recent federal and state legislative efforts to ban mandatory arbitration. So I will now turn to the PowerPoint, and we'll start with the Federal Arbitration Act, which, as you can see, is 9 U.S.C. sections 1 through 16. It's hard to believe it was enacted in 1925 because arbitration has really just become a bigger event in recent years. The purpose of the Federal Arbitration Act was to provide for judicial facilitation of private dispute resolution through arbitration. And there is a national policy favoring arbitration. You've probably often heard of the Moses Cone Memorial Hospital case. I've cited another case as well. But the policy favoring arbitration does not always supersede other considerations, which we'll talk about more later. Missouri has a state arbitration act. Although the Federal Arbitration Act doesn't contain an express preemption provision, the U.S. Supreme Court has found the Federal Arbitration Act to preempt state law where it's inconsistent with provisions and purposes of the FAA. There was a recent case in 2017 stating that AT&T Mobility decision, Kindred Nursing Centers versus Clark, which is in your materials. Historically, and from my experience, my first arbitration as an advocate was in 1990, and attorneys used the standard arbitration clauses that were supplied by arbitration service providers, such as the American Arbitration Association. People really didn't think about modifying a clause to address other issues, and there wasn't much case law about arbitration clauses and how they were construed. And although the standard and model clauses provide a good foundation from which to begin drafting, the clauses are by no means any longer one size fits all. Arbitration law, as I'm sure you have seen, has evolved exponentially in the past 20 years. And the arbitration clause needs to be tailored to cover issues that might arise in the event of a dispute. So let's move on to the drafting considerations. And the first question is, should the arbitration clause be broad or narrow? A broad arbitration clause, according to the Missouri Supreme Court, is a provision that covers all disputes arising out of a contract to arbitrate. I have included in the materials the AAA standard commercial clause that has the model pre-dispute clause for administered arbitration by CPR. Let's get our slide correct here. That goes further and says, including the breach, termination, or validity thereof, shall be finally resolved by arbitration. So as you can see, the key language is the use of shall, not may, and the fact that all disputes arising out of or relating to the contract or breach are subject to arbitration. However, I referenced the 1990 arbitration case I had, and it involved a dealer termination and a dealer agreement. And the clause, which I didn't draft, but I had to arbitrate, said that the claims, it was claims arising under the contract. And in that case, the plaintiff had filed a suit for dealer termination, and the defendant counterclaimed with some antitrust claims. And it was in the federal court under the FAA, and the federal court left the antitrust claims in the court and sent the rest of the case to arbitration. So you can see that drafting the arbitration clause and making sure that you include everything you intend to go to arbitration is in fact clearly reflected. My suggestion is that when you have a claim for fraud in the inducement, I've got an example to see whether fraud in the inducement would be covered under the AAA clause. And I would suggest including in any way, because there's a question as to whether fraud in the inducement would be considered by all courts to be included in the arbitration clause. A Missouri example is the lease on the stadium that was litigated several years ago, and the lease included language in the lease document that said that the attached arbitration agreement would apply to the lease, and then included the language that you see at the bottom: any controversy, dispute, or claim between the parties hereto, including without limitation any claim arising out of, in connection with, or in relation to the interpretation, performance, or breach of this lease shall be settled by arbitration. Such arbitration shall be the exclusive dispute resolution mechanism. In reviewing this arbitration clause, the Supreme Court quashed a writ of mandamus staying arbitration and found that the language clearly reflected the intent of the parties to arbitrate all claims. I've included another Missouri example, which also discusses the distinction between claims of fraudulent inducement of the entire contract versus a challenge specifically to the making of the agreement to arbitrate. And the agreement to arbitrate is considered a separate agreement within the overall agreement. In a narrow clause, you're limiting the arbitration to specific types of disputes. If the goal is to retain the right to pursue certain types of claims in court, or to be able to elect to sue rather than arbitrate, then a more limited clause should be used. However, it's critical that the language in the arbitration clause clearly and unmistakably express what claims the parties intend to, and those that they intend to include, and those that they intend to exclude from arbitration. Otherwise, you can end up with unintended results. And I have several examples. The first example arising out of this contract, again, the issue of the antitrust claims. Example 2, considering the carve-out language, and this relates to intellectual property, which you often see as an exclusion to arbitration, and the parties desiring to have intellectual property claims decided in the federal court because it has jurisdiction. The language here, excluding disputes related to the intellectual property, including but not limited to scope, validity, ownership, infringement. My question is, would a claim of non-payment of royalties under a license agreement be included as an arbitrable claim or excluded? So another example that the drafting has to be clearly stated. And with other contracts, my general principle is I write something and then I have somebody else read it to see if they have the same interpretation, because that's what happens. You get to court or you get to arbitration and you look at the clause and all of a sudden you start thinking about all the things that might be included or might not be included that you wish you would have thought about at the time you drafted the clause. Let's move on then to the rules. And Jennifer provided to me just before we started arbitration rules and procedures that Alaris has. And if you would like a copy of those rules, that you can send an email to adr@alaris.com and she'll be happy to send you a set of their rules. Oh, I'm sorry. It's alaris.us.com. It's, no, strike that. It's alaris.us@alaris.com. No. I'm going to let Jennifer tell you what it is.
It's adr@alaris.us.
Oh, it's adr@alaris.us.com.
No.
No.
All right, I'll just say it. It's
adr@alaris.us. That's it.
It's a good thing this isn't a technological program. The arbitration agreement should appoint an administrator that will make procedural and administrative decisions. And like Alaris, some administrators have their own rules. AAA has their own rules. JAMS has their own rules. And in fact, the arbitration section of the ABA, section on dispute resolution, is in the process of crafting rules that can be used if the particular servicer or the individuals have an arbitration for which there are no rules designated in the arbitration clause. Some administrators have rules that apply to certain kinds of disputes. So they have different rules for employment disputes, different rules for consumer disputes. And so it's important for you to be familiar with the rules that are going to apply in the event of the dispute. So I would advise you to look at the rules that you're going to include in your arbitration clause before you finalize the drafting and before execution, so you know exactly what rules you'll be bound by at the time a dispute arises, if it does. Let's move on then to arbitrator selection. One of the benefits of arbitration is the fact that you can provide what arbitrator qualifications you're interested in. It's not like going to court where it's the luck of the draw on who you get as a trial judge. So you can designate an arbitrator to have special training. In construction arbitrations, a lot of times the arbitrators aren't, or all arbitrators, if on a panel, are not lawyers. They can be architects, they can be engineers, people who are experts in an area at issue in the arbitration. I've seen people designate that they are interested in having an arbitrator who has X number of years of trial experience or some other expertise, so it can be designated in that fashion as well. Remember, arbitration is rooted in contract, and so it's a question of what the parties agree to. So the arbitration clause can be crafted in such a way that it covers exactly what the party desires going into the arbitration. The number of arbitrators is usually 1 or 3. It's obviously more costly to have 3 arbitrators. Some people will tell you that they'd like to have 3 arbitrators because they get people from different backgrounds and different experiences, and they are not stuck with one person who has one set of opinions. The question is, it's a cost-benefit analysis that you need to make with your client. You can change the number of arbitrators depending upon the value of the suit. You can say, you know, up to $100,000, we're going to use 1 arbitrator, but above $100,000, we're going to use 3 arbitrators. Again, it's a question of contract. So it is a question of what the parties want in the event a dispute arises. If you've read anything about arbitration in the last couple of years, you have seen a lot of writing about who decides arbitrability. This is often called a gateway or a threshold question. And it's a question of whether the court decides the issue or whether the arbitrator decides the issue. And again, it's largely a matter of contract law. There must be clear and unmistakable evidence of the party's intent to delegate the issue of arbitrability to the arbitrator. So where an agreement to arbitrate is silent or uncertain about who decides the issue of arbitrability, the law reverses the presumption that any doubts concerning the scope of arbitrable issues should be resolved in favor of arbitration. This is what I was referring to when I said that there's a policy favoring arbitration. But when you get to the issue of arbitrability, you have to show that it was the clear and unmistakable intent of the parties to delegate the issue of arbitrability to the arbitrator or arbitrators as opposed to having the court decide it. And as you can see from the case citations, the U.S. Supreme Court has weighed in a lot recently on arbitration issues. For example, recently in an opinion authored by Justice Kavanaugh, the court held that a valid delegation of arbitrability should be honored even if the court believes that arbitration is, that the argument for arbitration is wholly groundless. That's probably one of the most recent cases is the Henry Schein case. Under Missouri case law, the arbitrator decides the question of arbitrability if the arbitration clause contains an express delegation, as I just mentioned. And the Missouri Supreme Court has weighed in as well. In the State ex rel Pinkerton versus Fanistock case, the court determined that the agreement to arbitrate was sufficient because the parties incorporated AAA's rules into the arbitration clause. And on the next page, you'll see Rule 7, which shows that the arbitrator under the AAA rules has the right to determine its own jurisdiction. I think this has been an issue for people. The party has to specifically challenge the validity of the delegation provision to avoid its application. So often parties will challenge arbitrability or arbitration saying it's unconscionable, it's vague, etc. But in order to challenge the delegation provision, the party has to specifically challenge the delegation provision in the arbitration clause. There are several employment cases that have addressed this. Newberry was a case involving consideration in an employment contract, and the employee was challenging the arbitration agreement from the inception. And in Soares, it was also a consideration case, but the employee signed the arbitration agreement mid-employment, and neither challenged the delegation provision specifically. They said it was unconscionable, it was vague, but they didn't actually challenge the delegation clause. With respect to forum selection, the location where the arbitration will take place should be included in the agreement to arbitrate as well. And that, of course, is usually determined by the convenience of the parties and witnesses, local counsel, and local law. And one consideration is when you set the forum is to determine who will be deciding issues related to arbitration if there are issues that go before the court. and what is the law in that particular locale, because you could end up with something that you didn't intend. Mere inconvenience, of course, is not a basis for non-enforcement of forum selection, and forum selection clauses are prima facie valid and enforced unless they're unjust, unreasonable, or invalid. If it's a question of public policy, though, in Missouri, the courts won't honor the party's choice of law. And there's an example that was in front of Judge Jackson in which an insurance contract was involved. And in the highlights that I will discuss later to the Missouri Arbitration Act, insurance contracts are not subject to arbitration as against Missouri public policy. So that was an issue. So anybody who does anything related to insurance contracts or contracts of adhesion, also excluded from arbitration, should take a look at those cases. Choice of law, as I briefly touched on, is something that needs to be covered. And I recently saw reviewed a contract where the standard governing law provision was in the contract, and it had the application of one state law, and then it had an arbitration agreement, and it had the designation of another state law. So you need to make sure that the application of the law chosen in the contract is consistent. Consideration of whether it's more favorable for the FAA or the State Arbitration Act to apply also is an issue. And there are still some outstanding preemption questions that haven't been addressed because, as I stated previously, the FAA does not provide for state preemption, but the courts have applied it that way. You need to determine what impact the applicable law will have on the merits of the case. As I said, avoid inconsistency and consider including language when choosing the applicable state law to designate without regard to conflicts of law to avoid unintended surprises. Another state may have something that will affect your case because that state makes that particular issue an issue of public policy, and that's something that you need to determine to see if it will supersede your choice of law provision. This happens quite frequently in franchise cases. All laws related to vacation of awards as well are different from state to state. So another reason you need to look at the state's law to determine if the state law will be favorable. And again, because arbitration is an issue of contract, the parties can provide that certain things are subject to A law and other things are subject to B law. Because if the parties make it clear and unmistakable that that was their intention, that will be upheld as well, with the possible exception of the public policy exceptions. Another area that has gotten a lot of press is individual or class arbitration waivers. An agreement to waive class arbitration must also reflect clear and ambiguous intent to consent to do so. Silence about proceeding as a class is inconsistent with the FAA. That's the Stolt-Nielsen case. And the Supreme Court in 2019 held that the language in an employment contract was ambiguous and thus didn't manifest sufficient evidence of the party's consent to submit to class arbitration. Solely because an arbitration agreement contains a class action waiver, though, does not result in unconscionability in Missouri. So for the most part, class action waivers have been upheld by the Supreme Court as long as they express the clear and unmistakable intent of the parties. I provided some examples of class action waiver language. Of course, it's not exhaustive. The next area is the allocation of fees and costs. And under Missouri law, fees and costs are allocated as determined by the arbitrators unless otherwise agreed to by the parties. So if you want to provide for fees and costs and how you want them to be allocated, you need to include that in your arbitration agreement. The FAA does not contain a statutory section regarding attorney's fees. So if you want to address attorney's fees, it needs to be contained within the arbitration agreement. Some institutional rules set how the costs are allocated throughout the process. So if you agree that the AAA employment or consumer rules are going to apply to your particular case, AAA has specific provisions where they cap the costs for the employee or the consumer to $200 or $300 and provide that the employer or the company are responsible for all of the arbitrator compensation. So again, you need to look at the rules that you are incorporating into your agreement. Some institutions give the arbitrator discretion to award fees to a prevailing party. The other thing is, if you decide to include the right to recover attorney's fees, you need to make sure that you provide for, and you intend that the attorney's fees be covered not just in the arbitration proceeding, but any post-arbitration hearings. You need to include that in your arbitration clause and make it clear. The Brown versus Brown-Phil case showed that there was a subsequent motion to vacate the arbitration award, and the party attempting to recover their attorney's fees in the motion to vacate was unsuccessful because the court held that the clause did not cover those additional fees. Some clauses that I have seen have election language, and the Triarch Industries versus Crabtree case is an example of that, where the Missouri Supreme Court said it was a paint manufacturer and a paint, I think he was a distributor, and they provided that the manufacturer drafted the arbitration clause and provided that they could set the rules and solely, and that they could arbitrate or elect to litigate any issues. So an issue of payment came up, and Triarch proceeded to court to sue Crabtree for the non-payment. After Crabtree came in and filed an answer and counterclaim and significant discovery, Triarch decided, well, maybe they didn't want to be in court, they wanted to go to arbitration. So they filed a motion to compel arbitration. The court denied the motion to compel arbitration, saying you had the right to go to court or to arbitrate. You chose to go to court. It doesn't provide in your agreement that you can choose one and then change your mind and go somewhere else. You've made your election, you're now in court, and you can't go forward in arbitration. It was an interesting case, I thought, because the defendant made all of the vague and unconscionable, etc. arguments, probably thinking those were their strongest arguments, and threw in alternatively this election argument that they were foreclosed or had waived the right to go to arbitration because they had already gone to court, and that's the one that succeeded. So remember, although there's a policy favoring arbitration, it doesn't disregard the intent of the contracting parties as evidenced by their agreement. The intent is to a contract is presumed to be expressed by the ordinary meaning of the contract's terms. Just like any other contract principle, if the contract is unambiguous, it will be enforced according to its terms. If it's deemed to be ambiguous, it'll be construed against the drafter. And there's a Missouri case that I've cited for your information. There's another interesting Missouri case where it was a consumer case, and a company called NAF, I think it's NAF, which we don't have here in Missouri, was designated as the service provider. Excuse me. And because of challenges to the handling of consumer arbitration cases, NAF decided that they were no longer going to handle consumer cases. But the agreement didn't provide what would happen if the service provider was not available to hear the case. And the Missouri Supreme Court said, we are not going to redraft your arbitration agreement to include for an alternate. So, and they also construed it against A1 Premium Acceptance, who had drafted their may no longer be in business, may no longer accept those types of cases, that you make provision for an alternate provider. There are also preconditions to arbitration that can be placed in an arbitration agreement. In the franchise area, often there is a mediation requirement as a condition to arbitration, that the parties have gone to mediation and the mediation has been unsuccessful before they can pursue arbitration. Or sometimes there's language about the parties meeting to see if they can work things out, and if they can't work things out, then they'll proceed to arbitration. Of course, that's favorable to the company because they then have more of an idea of what the issues are. They've probably been clarified either in the meeting or in the mediation. But cases get dismissed when the party goes to arbitration and there was a precondition. So you need to be aware of that. There are other considerations as well, such as the timing of arbitrator selection, how many days to select an arbitrator, how long before the hearing has to be had, and when the award needs to be entered. Usually, if you use a service provider, these issues are already addressed. The entry of an award, generally, what I see is 30 days. Certainly those can be modified again because of contract. The issue of confidentiality is an interesting one because arbitrators are subject to confidentiality with arbitrations. They can't discuss the arbitrations, they can't discuss the content of the arbitration, but the parties, unless they agree, can go out and talk about the arbitration. They're not prevented. They aren't subject to confidentiality. This is an issue that doesn't get addressed very often in arbitration agreements, but something that people should consider when deciding to use the arbitration process. Limitation of damages. It's not infrequent that I see no punitive damages can be awarded, no consequential damages can be awarded. So limitation of damages is something else to consider. And I want to go back for just 1 second because it popped into my head, and that is when you talk about choice of law, different states perhaps have caps on damages. And so that's something to be considered as well. Although, you know, the venue is going to have some application, but you don't have to go back. It's okay. We're working in tandem here. And specified damages, delay damages, et cetera, if you've got a construction case. There is a clause builder tool that AAA has on its site, so I just mentioned that. You can look at that, and that might be helpful when you're drafting an arbitration clause. And the one thing I can't stress enough is, and I really, I guess, just given my years of practice, feel like if you're a transactional lawyer, you really need to know something about litigation or get some litigation experience so that you can see what happens when drafting goes bad. What issues arise because something was not drafted as clearly as it could be, which is the reason I say it's helpful to have somebody else read your language after you have put it together, because different people see different things within the language. So we'll move on to the Missouri Uniform Arbitration Act, and I'm just giving you some highlights. It's in section 435 of the Missouri statutes. And we've already discussed the fact that Missouri law deems arbitration agreements and contracts of insurance and adhesion invalid as against public policy. Have a couple of case sites there for you. And a motion to stay a lawsuit pending arbitration and the denial of a motion to compel are appealable, but an order compelling arbitration is not appealable. So if there's a motion to compel arbitration, you go through the entire arbitration and then raise the issue at the end, which, you know, seems to be a costly endeavor. A motion to modify an award can be filed, and the motion to modify that you ask the arbitrator to make a modification or clarification is really ministerial or you know, an addition problem or something like that. It's not a substantive issue. There's no review on the substantive issues. Those are covered in a motion to vacate, but you can file the motion to modify or clarify at the same time you file the motion to vacate. And a motion to vacate has a time limitation. My recollection is it's 90 days, but it's in section 435, 405. There's a notice requirement in Missouri that requires, if the Missouri law applies, that you include this substantial language. This contract contains a binding arbitration provision which may be enforced by the parties. It has to be adjacent to or above the space provided for the signatures. It needs to be in 10-point type. It needs to be in all caps. It's similar to a notice to owner in a construction case. However, the Missouri notice provision can't be used to defeat arbitration under the AAA. So let's discuss mandatory arbitration, which of course is arbitration that's required. And it's often seen in employment relationships and the sale of consumer products and services. It's becoming more and more prevalent. And sometimes it's referred to as forced arbitration. And before I go to open it up to see if anyone has any questions. Okay, seeing no questions, we'll move on. So there have been recent efforts to attempt to ban mandatory arbitration, as I said. And since as early as 2007, there's been legislation that's been introduced in Congress to ban what they call pre-dispute arbitration, which is arbitration that somebody agrees to at the time they sign a contract, not at the time the dispute arises. And the original legislation covered employment, consumers, franchises, and civil rights. I happened to write an article about this legislation in 2009 related to my area of franchise law, and for some reason in the next set of legislation, franchise law or franchises did not appear any longer. I suspect that the IFA got its lobby out to have that removed. But our good friend, the comedian Senator Al Franken, was the stalwart in this area before resigning from the Senate in 2018, along with a senator from Georgia. But even with Senator Franken gone, there have been recent signs of movement toward passage. There's been sort of a groundswell really relating to or arising out of the employment arbitration area. And the Forced Arbitration Injustice Repeal Act passed the House this year and was referred to the Senate Judiciary. They've been kind of busy, I guess. Well, maybe not, because they were foreclosed, they told me last night on PBS, but from the impeachment hearings. But the FAIR Act, as it's called, seeks to prohibit pre-dispute arbitration agreements that force arbitration of future employment, consumer, antitrust, or civil rights disputes, and agreements and practices that interfere with the rights of individual workers and small businesses to participate in a joint class or collective action related to an employment, consumer, antitrust, or civil rights dispute. So, having no success in the courts, people are going to Congress to try to change the law to exclude pre-dispute arbitration and class action waivers. California, always being out ahead of everybody else, signed into law on October 10 of this year, AB 51, which bans mandatory arbitration agreements under Fair Employment and Housing Act and the California Labor Code. And it bans arbitration agreements in which employees must take an affirmative action to escape arbitration, like opting out. It's supposed to take effect January 1, 2020, but most people think that it's likely to be preempted because it is inconsistent with the FAA. So it's something interesting to watch, especially if you practice in the employment arena. In response to Epic Systems upholding class action waivers, plaintiffs filed a number of individual suits in California trying to impose significant costs on employers because employers in California have to bear 100% of the arbitration costs. And so California Senate Bill 707, signed into law on October 10th, also set to go into effect January 1st of next year, requires the drafting party of an arbitration agreement to timely pay the arbitration costs within 30 days and a failure to do so results in a default and allows the employee to get out of the arbitration clause, and also provides for adverse evidentiary consequences. So California is pushing the envelope to see if they can get anywhere in the courts while they're also pursuing legislation. There's also legislation being pursued in Congress. I have completed my presentation, and again, we'll ask if there are any questions anybody has.
This is Jennifer. So I do have a question, Jane. Earlier you talked about confidentiality concerns. And I don't know how often this comes up. This comes up frequently at Alaris, as you can imagine, given the different types of cases we handle. But I'm curious if that's more in like the drafting stage is where the parties would be more concerned about the confidentiality of the outcome, or if that's more something you would work on, when it's become evident that you are going to arbitrate the case, or both. I guess I'm not clear on that.
Well, normally when I see it is the parties are before me in arbitration, and all of a sudden there's something sensitive and one party wants to have the other party agree to confidentiality of the discovery. And at that point, it depends on whether both parties agree, because if both parties don't agree, there is no agreement. If it's done at the time of drafting, which I really don't see very often, then the parties agree up front, and it becomes it's confidential if they get to the situation with a dispute.
Am I slow? So just quick follow-up to that. So it's not so much a confidentiality concern about the award, it's more about evidence that's been presented or discovered through the discovery process.
Well, it actually could be both, because one of the reasons why franchise companies started using arbitration more significantly was because they didn't want to disclose results of awards and information. They didn't want people sharing information that they got from one arbitration in another arbitration. There are some federal laws that I won't go into that might require disclosure anyway, but it's both, could be information exchanged by the parties, or it could be the award itself. Good question.
Does anyone else have, I don't see any questions online. If anyone online, I see a bunch of you there. Oh, there's a question. All right, so this is the question. Hope you don't mind me saying it's Judge Van Amberg. In the formation of the arbitration agreement under Missouri law, for example, do issues of mutuality still arise in court in challenges to the enforceability of the arbitration agreement? Does that make sense?
And the answer is yes.
Okay. Say it again.
I'm going to type the answer so it's safe.
Oh, okay. The short answer is yes. We have more time to fill, Jane. Can you elaborate on that a little?
That takes us down a whole different path. So I will deflect.
Okay. Anyone here have anything you want to ask? I do just have kind of more of an opinion question as far as where you see the law going. I know you touched on it a little bit at the end there, but I just wonder what your thoughts are and where you kind of see us going. I know you're very involved with the ABA and larger organizations.
Well, it's interesting because the ABA section on dispute resolution has been going back and forth between different committees, as you can imagine, the people who do employment work on the employee side, the people who do employment work on the employer side, et cetera. So they have discussed different resolutions that the ABA would like to push out related to arbitration and mandatory arbitration. But it has to go through all the processes, and obviously everybody has a different interest. I do think that there is certainly a significant increase in the use of arbitration. And, you know, one opinion is people say, well, it takes just as long and it's just as much cost, or it's more expensive. But, you know, a lot of that goes to arbitrator selection, and the parties working with each other and controlling things. For example, you know, one time I had a case where somebody provided, I said, you know, you can have some requests for production. And so somebody sent out 200 with subsets. And I learned that lesson once. I had to sit all weekend, you know, going through it and figuring out whether they were acceptable or not acceptable. And I don't allow that, obviously, any longer. And if a party is going to arbitration because it's going to be more cost effective, obviously, you know, there's a lot of discovery that may otherwise be unnecessary, and to just want to do discovery to bother the other side isn't a good situation. So, like with respect to depositions, you know, I usually ask people, well, what, you know, if you want to take this many depositions, whose deposition do you want to take? And, you know, what information are you looking for? Because the idea is for the parties to cooperate and exchange information. And if they don't have a good basis for why that particular individual needs to be deposed, then, you know, I don't agree to the additional cost. But a lot of times there are people want to file motions or dispositive motions, and that's become a big issue in arbitration. But because arbitrators don't often get overturned for accepting information, because they can give it whatever weight they want, but they do get overturned by exceeding their authority or refusing to allow somebody to do something that they should have been allowed to do. The likelihood of a dispositive motion being ruled on favorably is minimal. And generally, people file dispositive motions right before hearing. And I always say, well, you know, you're going to spend all this money preparing a dispositive motion, but the hearing is right around the corner. Do you really want your client to spend that kind of money when you're going to be presenting your case anyway? So a lot of that has to do with, you know, who are the arbitrators, what's their, you know, how do they handle things, and what's their style, and so forth. So, you know, I think a lot of times people give short shrift to what they put in an arbitration clause. They just do the old-fashioned thing and take a standard clause and put it in without really thinking much about what can happen down the road, which is the reason for my talk today.
I don't see any more questions online. So if anybody has any, now is your time. You got one? Okay.
Just so you all know, we've got 3 people who are brave enough to show up in person.
Jane, if the contract that's drafted is silent as to confidentiality, as Jennifer brought up, in your experience, can the arbitrator order confidentiality of award and information?
Personally, I would say no. I haven't read a case, but personally I would say no, because it's an agreement of the parties, you know, it's a contractual principle, and the parties haven't agreed to confidentiality. So I would say that unless the parties agreed to maintain confidentiality, the arbitrator can't award it.
Thank you.
I was going to ask if you agreed with me, but since you're you serve as an arbitrator, but we'll take the benefit of your knowledge.
Well, in my experience, if it's ordered, I can't imagine who would try to appeal that section. It just wouldn't be worth, would it be worth the time and money to say, I disagree with that. I'm going to appeal that and dispute that or whatever, not appeal it, but try to have that portion of it overturned. That's just the practicality of it that I've run into. And it might be awful beneficial to both parties to take that extra step. But
What's your position on the legal aspect?
I'm agreeing with you. If somebody wanted to dispute it because it's not part of the agreement to arbitrate, that they'd probably be successful. But
Well, I've seen this issue come up more and more during arbitrations, where a party wants to maintain confidentiality because the lawyer has now stepped in and sees maybe information that they don't want disclosed and so forth. And it wasn't anticipated at the time the parties entered into the contract. So it just seems that that's probably the safest tack to take if that's the desired result.
sure. Thank you again.
All right. Well, thank you very much, Jane. This is very informative. Lots of slides here. Thank you to everyone who attended in person. And this will conclude our webinar. And we hope that you all will join us for a future webinar. Thank you.